Welcome, everyone. This is the Unit 4 hearing for the National Invitational for Fishers Junior High. My name is Ryan Susky. I'm Director of Programs at the Ohio Center for Law-Related Education, and I'll be serving as the facilitator for today's hearing. In just a moment, I'm going to have the judges introduce themselves, followed by the students, and then we will begin the hearing. The process we're going to follow is that students will deliver a 4-minute prepared statement, followed by 8 minutes of judge follow-up questions. Now, my microphone will be muted during the hearing, but I will be holding up the 1-minute and time signs, so I do recommend that you use gallery view to make sure you can see my time signals, and of course, you can see your colleagues. At the conclusion of the hearing, judges will give brief feedback to the teams, and then we'll be on our way. With that, I'll go ahead and hand things over to your chairperson for today's hearing to begin the introductions.
Hi, Fishers. Nice to see you again this morning. I'm Diana Owen. I'm Professor of Political Science at Georgetown University.
Good morning. I'm Deshawn Whitaker, We the People teacher in Charles County Public Schools in Maryland.
And I'm Joe Stewart, Professor of Political Science at Clemson University in South Carolina.
And if you could please introduce yourselves and your teacher.
Hi, I'm Tanvi Pathuri, the captain of Unit 4, and we're from Fishers Junior High in Fishers, Indiana.
Hi, I'm Jenna Talbot.
Hi, I'm Sam Bass. And I'm Claire Reeby, and our instructors are Mike Fossold and Tony Sturgeon.
Great.
Great, thanks so much. So, of course, the question for today is, no surprise, number 2. Quote, if a law has been properly passed by the lawmaking branches of a democratic government, why should judges have the power to declare it unconstitutional, unquote? Do you agree or disagree with Robert Dahl? Why? What is judicial review and why is it controversial? What has been the impact of judicial review on American society? Once the Supreme Court has decided that a law is unconstitutional, what power, if any, do the people have to change the Constitution? Please begin.
In Federalist 51, Publius insinuates that there must be civil checks and balances between the different departments of the government, thus proving that even the framers, as well as our unit, disagree with Robert Dahl. Even the finest governments require checks on and from all branches to eliminate one omnipotent fragment. Judicial review visibly affects policy outcomes of departments such as the executive and legislative branches. The Supreme Court can overrule any department's decision by the opinion of a majority of judges. The concept of judicial review stems from Magna Carta, where 25 barons were granted the power to check the king's decision. But most importantly, Marbury v. Madison established the idea of judicial review in our government. In this case, Chief Justice John Marshall and his associates asserted the right that the Supreme Court could determine the validity of congressional law.
The court ruled that a recent law had expanded the Supreme Court's jurisdiction beyond what was stated in the Constitution and rendered that law unconstitutional. However, judicial review has a long history of controversy because judicial review is not established in Article 3 of the Constitution. Yet, it gives the Supreme Court unchecked power to look over the constitutional validity of an executive or legislative action. Alongside this, judges bring with them their ideology, biases, and opinions, which could potentially change a court's decision and affect the defendant's due process of law established in the Fifth Amendment. In Federalist 78, Publius countered the idea that legislatures should be left to enforce the Constitution upon themselves. It stated, where the will of the legislature, declared in its statutes, stands in opposition to that of the people, declared in the Constitution, the judges ought to be governed by the latter rather than the former.
Consequently, our government has benefited, yet also set ourselves back with judicial review. Buck v. Bell, a 1927 Supreme Court case, argued that imbecility, epilepsy, and feeble-mindedness are hereditary, and that citizens should be prevented from passing these defects to the next generation using sterilization. Since the courts did not clearly define feeble-mindedness, it sets a harmful and unjust authoritative example, meaning any person could argue feeble-mindedness and take advantage of residents in such institutions. Nevertheless, judicial review has brought about needed change. as seen in the 1967 Supreme Court case Loving v. Virginia. This case argued that interracial marriage, specifically between white and Black citizens, should be legal. In a 9-0 decision, interracial marriage was legalized due to the prohibition violating the equal protection and due process clauses in the 14th Amendment.
Both of these cases prove that judicial review is not a clean-cut issue and has many layers within. But the court's rulings are not always the final word. The people have multiple ways to change the Constitution after the Supreme Court has ruled on a decision. A decision can be overturned by passing amendments to the Constitution, such as when Chisholm v. Georgia was overturned by the 11th Amendment, as well as Dred Scott v. Sanford being overturned by the 13th and 14th Amendment. The people can also elect presidents with the intent that the president will appoint a certain judge with similar ideologies. This can be seen in the 2016 election when a Supreme Court seat was waiting to be filled by the next president. And again, in the 2020 election, where stacking of the courts was an immensely discussed concept. While judicial review is a highly debated subject, it is undeniable that it has become a predominant pillar of our government. We have finished our testimony and are now ready for your follow-up questions.
Great, thank you very much. I'd like to start out with a question about the selection of judges. Do you think that the Supreme Court justices should be elected by the people, or do you think the system works as it is?
I do not think that judges should be elected by the people because the judge's job is to represent the Constitution and to uphold constitutional law. When people elect presidents and the representatives, they elect them because of their ideals and their beliefs and what they may bring to office. But all judges have to do is represent the Constitution.
And you can see in the Georgia Senate runoff, it cost over $1 billion in just that runoff. So how much would it cost to essentially buy the Supreme Court?
And it was the framers' intent in Federalist 78 to keep the judiciary away from the public and not have public pressures in how they interpret the Constitution.
And building off of what Sloan said, with Citizens United, we can only imagine how much dark money and coercion could go into the potential election of a Supreme Court seat.
Thank you for that answer. So let's continue on that path. How do you feel about the life term of the judges?
I think the judges should have a set term, and I believe this simply because it would create more regular vacancies in the court, which would allow the judges to more accurately reflect the public.
And parties and presidents generally scramble when there's a vacancy to find the youngest, most ideologic candidate, which just further politicizes our courts. And when we have more vacancies, we would get a more diverse opinion and not politicized.
However, we can see in Article 3 of the Constitution that judges continue to stay in office on good behavior.
And I think that the purpose of lifetime appointments is to avoid external pressures. And I think they've been doing a good job of that with lifetime appointments. So I think we should keep it how it is.
And with lifetime appointments or term limits, it would be important that the judge has term limits that exceed a double term or a certain president's powers. So they aren't restricted to that party or president's decisions.
Okay, I want to go back to one of the cases you cited, make sure I understand what you were arguing. You talked about Buck versus Bell as a case where the court did not define what feeble-mindedness was. Are you arguing that the court should get involved in defining something like that? Or should the court do what it did in that case and simply decide a legal principle, but leave it to other courts to decide the facts in the case?
I mean, the argument made in this case in our paper is that the court allowed eugenics into the court, which isn't something that they should check the constitutional validity of, because it's an overreach of their power.
And I think that feeble-mindedness is so broad. How do you define if someone is feeble-minded? What is it, the decisions that they make? Is it how they are? Just how do you define that? And that just made it a bad decision by the court, because just who defines that? What is the definition of that?
And I think the biggest point of Buck v. Bell was that it was a great oversight of the court and of the government into women being able to have their own children, and it shouldn't be if they have a certain mental disability.
But if the court then says that we can't execute someone who's mentally retarded, which was the term at the time they did in Atkins versus Virginia. Is that the same kind of thing you would suggest the court shouldn't get involved in that?
Yes, because how are they to define that? It's like, it's their job is to interpret the Constitution, and how are they interpreting that, the Constitution?
And again, the court being able to set those very authoritative positions on certain different topics I think is very dangerous.
So I'd like to follow that up with a question about judicial activism and judicial self-restraint. Can you talk a little bit about what those terms mean and whether you feel that the Supreme Court is justified in being activist or whether it should be more restrained in its decision-making?
I think ultimately it can depend on the case of how they interpret the Constitution, because there's different ways to interpret it, like loose and strict. And an example of loose interpretation would be like DC v. Heller, where the gun prohibition and how we didn't have the guns that we had back,
I think what my teammate is trying to say is the Justice Scalia, who wrote the majority opinion on DC v. Heller, struck out the militia clause of the Second Amendment to more accurately fit that to our times of today, which goes back into what is a loose interpretation of the Constitution, and that is interpreting the Constitution to be living and changing with the times.
Yeah, and another case of loose interpretation is Brown v. Board, which brings about change, which is taking an activist approach, but at the same time, a textualist or more self-restrained approach is much safer, and that the judges can't bring in their own biases and call it a loose interpretation, as seen in Minor v. Happersett.
In Minor v. Happersett was a strict interpretation because they said that women are citizens, but citizenship does not, you don't have the right to vote under citizenship. You don't need to be a citizen, or you have to be a citizen to vote. But even though women are citizens, that doesn't require to vote.
Just to refine that, basically in the decision in Minor v. Happersett was that the right to vote was not protected under the 14th Amendment.
All right, thank you. What are your thoughts on the argument that judicial review is essential to protecting the rights of the minority against the will of the majority?
Well, as stated in Federalist 78, our liberty could be infringed on if the judging power was given to the legislative or the executive.
And especially seen with the iron triangle that Congress is intertwined with bureaucracies and independent interest groups, it's very important that the judiciary comes back and checks that, as the interest groups don't run our government and enforce laws.
Also, judicial review protects the people from the government, as seen in Magna Carta, where the 25 barons were able to check the king's decisions.
And the judicial branch is in Federal 78. It's the intermediate body between the people and the legislative.
And we can see, building off Claire's point, in Texas v. Johnson, the Supreme Court upheld that the people's First Amendment rights were protected in flag burning.
You mentioned interest groups, and do interest groups not have any impact on the courts? Or can you think of how they do have some impact on the courts?
Well, the court's job is not to reflect the people, but to reflect the Constitution. That is their job. Their job is to interpret the Constitution and how it would apply to our cases today.
Okay, thank you.
Thanks very much for that really nice opening statement and the stimulating discussion. Now we'll give you some feedback. I really thought you did a great job on the opening statement, where you even went back to the Magna Carta, and again, you referred to it in the Q&A as well. You showed a strong knowledge of Supreme Court cases as they were related to the topic, and you linked them nicely to the Constitution, specific articles in the Constitution, amendments to the Constitution. So that was a real strength. I thought you did a good job of talking about the ways that people can change, can have some influence on the process through the amendment process, and particularly through the presidential appointment process, which has become so controversial recently. And you wisely brought up the 2016 and 2020 elections and how that became an issue. And kind of it's still kind of an issue in the works now with President Biden appointing a commission to study whether we should expand the number of cases on the justices on the court. So I thought that was great. I really liked your answer to my question about, well, should we, have the people select the Supreme Court justices? And you again related it to the Constitution, brought up the Georgia Senate race and the cost that this would take. That's something I guess I hadn't considered as much, and I thought that was a really good take on it. And then related it to Federalist 78. And then the follow-up with the life term, also very carefully considered. Just the conversation is so rich, and your depth of knowledge is just so clear. Once again, I was very impressed with your answer to yesterday's question, and I feel the same way today. Great job.
You're muted, Daishan.
Yeah, there we go. I agree with my colleague. Outstanding. Enjoy speaking with you. Everything, your knowledge is there. I mean, you can tell us any question we ask you, you've got it. So you thoroughly understand this unit. You understand the complexity of this argument. You have the court cases to back it up. You have the contemporary examples today from the Georgia election. You've got it. Just well done. Well done.
My colleague emphasized your depth. I want to emphasize your breadth. But before I do, I want to say that the very strange sound that you're hearing is not a malfunction on Zoom, but it's Justice Scalia being called a loose constructionist, and he is spinning in his grave now. Your assessment of his opinion in Heller, I think, is correct, but Justice Scalia would be appalled by your description, however accurate it is. I really like the breadth, as my colleagues already mentioned, from the Federalist Papers to the Magna Carta to a great selection of cases. I would say wrestle with this as you go forward, and you have the equipment to do this. You're prepared yourself. You criticize the court for saying, well, in Buck v. Bell, they talked about feeble-mindedness, and I brought up the Atkins versus Virginia case. They are dealing with legal issues. In Atkins versus Virginia, what they're wrestling with is interpretation of the Eighth Amendment. Is it a violation of cruel and unusual punishment prohibition to execute someone who's mentally retarded? And then to the point you raised, yeah, we don't want the Supreme Court deciding who is mentally retarded and who isn't. Well, what they do is send that back down and say, okay, here's what the Eighth Amendment means. And you go decide whether or not Daryl Atkins is in fact mentally retarded. So there are these connections here where they can focus on legal issues, which is what we want the court, and you argue, we want the court deciding constitutional standards, but it's going to involve real world issues. That's why we bring these cases to the Supreme Court. And but the great news is I am very pleased and confident that you are well equipped to deal with these issues, and you did a great job. Thank you again for our conversation today.
Yes, thank you again, and thanks to your teachers. Again, outstanding job preparing the team. And I love the way the team works together and, plays off of each other. Just great dynamic.
Well, you're looking at people who probably will be governor of Indiana at some time. So,
Yeah, and
thank you, judges.
yeah, draw on your knowledge when you talk about the expense of court races. I don't know Indiana judicial elections that well, but you go next door to Mr. Susky's state of Ohio, and what the point you were making about how much it would cost to elect people to courts is a very real issue there. So,
Right. Yeah, we talked about that. We look at the last Supreme Court seat, how much money actually went into, putting pressure on the Senate to vote for her. And these kids are smart enough to realize a national election would be the most expensive races in the history of races. But judges, thank you so much